Most criminal cases in the United States are prosecuted by state and local governments and heard in our state and local court system. Less than 1% of criminal cases are prosecuted by the United States and heard in our U.S. district courts. It's this small category of criminal cases that we specialize in defending here at Burnham Gorokhov. And in this video, I'm going to talk to you about 3 important ways in which federal criminal cases are different than other types of criminal cases. First, and perhaps most obviously, federal criminal cases are based on United States federal criminal law, starting with the United States Code written by Congress, which contains over 1,000 criminal offenses affecting almost every aspect of our daily life, including our banking system, including government contracting, healthcare, pharmaceuticals, and many other things. These laws over the years, over the decades, have been interpreted by our federal courts, the courts of appeals, the district courts. And if you're facing a charge of this type, you need an attorney to help you that's familiar with this body of law and can explain what it means for you in your situation. Also, there's a body of procedural law, the federal rules of criminal procedure, statutes, and so on, that dictate the way criminal cases progress through the system. That governs the defendant's ability to obtain pretrial release. It governs the defendant's ability to appeal a criminal conviction. It governs the right to a speedy trial and many other important rights. Finally, there's also a robust body of federal law surrounding criminal sentencing that's developed particularly over the past 30 years or so. Many criminal offenses, felony offenses, carry extremely wide ranges of punishment, 0 to 20 years, 0 to 40, and so on. And an attorney that knows something about federal sentencing law can help you understand what you might be facing based on your criminal charge. So that's federal criminal law. What's the second way? The second way in which federal criminal cases are different. That is, the criminal charge is much more likely in the federal system to come as a result of a lengthy, thorough, sophisticated criminal investigation than it would be, say, in the state system. One of the most fundamental reasons for this is that federal criminal prosecutors, we call them United States attorneys, are not expected to prosecute every violation of the criminal law, the federal criminal law, in their jurisdictions. They have wide latitude, or in fact expected to, choose only select cases, and the best way to illustrate that is the way federal fraud cases are handled. Most U.S. attorneys' offices, everyone we've ever dealt with here at the firm, won't touch a federal fraud case unless the loss amount to the victims is at least well into the hundreds of thousands of dollars, perhaps higher than that. So, because the federal prosecutors select such a limited number of cases, they can put that much more time, resources, and effort into investigating and preparing the cases, all of this backed by the power and resources of federal law enforcement, which means the FBI, which means DEA, Homeland Security, and so on. All of these agencies have enormous capabilities of electronic surveillance, wiretaps, other sorts of technical ways to gather evidence. That means forensics, that means searches and seizures, and so on. And so if you're facing a federal criminal investigation or charge, you want to have an attorney to represent you that understands these investigative techniques, has the resources and the time to organize this evidence, understand it, explain it to you, have you explain it to them, and ultimately be able to defend against it, which is not easy to do. Finally, and perhaps most importantly, federal criminal cases are unique because they typically involve much more serious allegations than another kind of criminal case, which carry much more significant penalties. In our state courts, the judges there have a wide array of non-incarceration means to address criminal conduct that they use to deter it, to rehabilitate offenders. Many cases result in probation or very short jail sentences. There's drug courts, there's other sorts of deferral programs. These sorts of things do exist in the federal system, but they're much less frequently used, and sentences in the 5, 10, and even higher range are common. The takeaway: federal criminal cases are serious. You should prepare them from the outset. You need an attorney to help you that understands everything involved, including the issues I've talked about. Now, this discussion has necessarily been quite high level, quite general. I invite you to visit our website if you're interested. We have material there on different kinds of federal criminal charges, the details on those, articles discussing federal criminal procedure. And if you don't find the answer you're looking for from this video or from our other content, please reach out to the firm. We can have one of our attorneys talk to you in a free consultation and tell you what we can about your situation. Thank you very much for watching.